The intersection of federal immigration law and Utah divorce. One of the most difficult situations in Utah family law arises when federal immigration remedies collide with a state divorce case. Under the Federal Violence Against Women Act, or VAWA, a qualifying non-citizen spouse married to a United States citizen or lawful permanent resident may sometimes seek immigration relief independently. A VAWA self-petition may proceed without the citizen spouse's participation or knowledge. A related remedy, VAWA cancellation of removal, may be raised in immigration court. Both forms of relief require evidence of battery or extreme cruelty. VAWA is essential for genuine victims whose immigration status might otherwise be controlled by an abusive spouse. But the structure also creates a serious tension. If a non-citizen spouse believes divorce may end the ordinary path to lawful permanent status, an exaggerated or fabricated abuse allegation can become a tempting strategy. The federal and state systems operate very differently. A VAWA self-petition is confidential and non-adversarial. Immigration court proceedings are adversarial, but the accused spouse is ordinarily not a party. The citizen spouse may receive no notice, see none of the evidence, and have no opportunity to respond. Utah Family Court, by contrast, is adversarial. Claims affecting child custody, parent time, and property and debt should be tested through testimony, documents, and cross-examination. Yet an abuse narrative developed from immigration purposes or for immigration purposes may spill into the divorce case and immediately affect temporary orders, possession of the home, access to children, and negotiating leverage. That does not mean courts should presume a VAWA claim is false. They should not. Genuine victims need meaningful protection. But courts should recognize the incentive structure and test the allegations carefully. For the accused spouse, the response must be disciplined and evidence-driven. First, preserve everything. Text messages, emails, voicemails, photographs, financial records, travel records, and communications with friends and family. Objective records can confirm or contradict claims of isolation, financial control threats, or physical intimidation. Second, comply perfectly with every temporary order. Even an unjust order must be obeyed until modified. A violation can create new evidence and distract the court from the original dispute. Third, use lawful discovery aggressively but carefully. Immigration records may be protected by confidentiality rules, and access is not automatic. But where state court discovery is legally available, counsel should seek relevant statements and communications and compare the factual account presented in one forum with the account presented in another. Inconsistency does not automatically prove fraud. Trauma, fear, memory, and context can explain differences. But neither should courts treat every inconsistency as meaningless. The central question is not whether the spouse is an immigrant, it is whether the allegations are true. Legitimate VAWA claims protect real victims and deserve respect. Manufactured claims damage the accused, distort child custody decisions, and undermine confidence in both immigration law and family court. At the intersection of these two systems, the only reliable guide is evidence.